panel's report was riddled with legal and factual errors. And then there's another important point, which I'll add to it. In addition to other pending procedures, such as investigations by the Hawks, the ANC took the view to be unconstitutional to proceed. Now I ask this court, what has the Hawks got to do with this case? What has the Reserve Bank got to do with this case? What has SARS got to do with this case? What has the Public Protector got to do with this case? Nothing. They are not. So that in and of itself is the height of irrationality. Even if one accepts the debate that we've had this morning concerning the question of whether the panel got it right on prima facie and the question of sufficiency. By the way, the ATM says the panel's report is perfect. It's inch perfect. And any suggestion that it was riddled with legal and factual difficulties is wrong. And I'll come to that. But at first instance, there are two reasons. If one of those reasons is bad, we win. That's this court's jurisprudence, Westinghouse, etc. If there is a decision maker, such as Parliament, egged on by the ANC, and one of the reasons by the ANC which eggs on Parliament, one of those reasons is bad, the decision is bad. With inaccuracies because of what he stated in paragraph 30 of the ANC's heads and what he stated in the President's heads. Perhaps the President's heads do it in perhaps a neater way, and that is in paragraph 52. They start with three reasons. This is the panel report. So this is why the President says the panel was bad. And they give three reasons. The first reason, the panel must...
Can't save it by saying, oh, well, there's a good reason, because the report was riddled with inaccuracies.
Prima facie.
Now we turn to why was the report riddled with inaccuracies? Well, the report was riddled with inaccuracies because of what he stated in paragraph 30 of the ANC's heads and what is stated in the President's heads. Perhaps the President's heads do it in perhaps a neater way.
It's another problem with the report, the President says. And the third one is, above paragraph 58, no inquiry into bad faith. Three reasons. Why the report is bad. That's what the President and the ANC rely on. The ANC in paragraph 30 sort of develops it in some kind of a nuance. That is in paragraph. Let's start off with the third one. They start with three reasons. This is the panel. The report to do one thing. This is why the President is what I'm going to call in Cape Town terms a rubbish reason. Paragraphs 58 to 63 of the panel report. It's pages 86 to 87. There, the panel deals with bad faith. It explains what it understands by bad faith in detail. So when the President says to Parliament, so when the President says to this court, and the ANC says to Parliament, says the panel was bad. The panel got it wrong because it didn't. And they give three reasons. Of course it did. Look what it said. The first reason, the panel misunderstood its mandate. That's the sufficiency of evidence, the prima facie issue. But earlier, and there are bad faith is 5 paragraphs, or 4 paragraphs, 52, 3 and 4. dealing with what the Chief Justice Mufweng said in the Public Protector of South African Reserve Bank case. 63, they conclude, and they go to the dictionary definition of bad faith. Paragraph 63, we think that bad faith can be inferred from the nature and the circumstances surrounding the violation of the Constitution of the law, constitutional law and misconduct.
The next problem that
the President dismisses a Director General because he wants to appoint in his place his relative. And then it explains where the President gets it wrong. He acts unlawfully, but not in bad faith. He's given advice by a lawyer, and the President makes a mistake. He brings the Pharmaceuticals Act into operation. It wasn't in bad faith. He made a mistake. He acted irrationally. Bad faith is when he wants to appoint his relative to the Director General, or he gives a criminal a pardon because the criminal paid him to do so. That's bad faith. And the question arises, we've been in democracy for 50 years. How long will we wait for a president to come to a panel and say, yes, I acted in bad faith? Never. It will never happen. Every president will come to the panel and say, I acted in good faith. I made a mistake. So the bad faith argument by the ANC, one of the three pillars, falls. The panel did look at bad faith and it said, we're going to look at what happened. The couch, the reporting to General Roder without going to a proper policeman, all of those things. And the panel says that's bad faith. Wrongly or rightly. But you cannot criticize the panel for not inquiring into bad faith. They did. The second, let's go going backwards. The second problem the President identifies. The President equated evidence with information. Let's look at what the rule actually says. The rule says what the panel can do to come to its decision on sufficiency of evidence. It's in 129G. 129G. 129G, paragraph 1, paragraph C. It says, in considering the matter, the panel may in its sole discretion afford any member an opportunity to place written or relevant written or recorded information before it with a specific time frame. Must provide the President immediately with copies of all information. Must provide the President with a reasonable opportunity to respond in writing, etc. 4. Must not hold an oral hearing and must limit its inquiry to the relevant written and recorded information placed before it by its members, and must in its report include any findings, including the reasons for such findings. And now what the ANC and the President do is they say, there's a heading, they say when the panel looked at the information, it was a flawed consideration because it could only look at admitted evidence as per a court of law. Wrong. It's information that will give rise to sufficient evidence or may give rise to sufficient evidence. How can the admissibility of information from the President who may only write, they can't hold hearings, how can that ever be equated to the requirement of admissible evidence in a court of law, an affidavit or a person who swears on oral oath? You can't even have an oral hearing. That would be counter to common sense. So the ANC's and the President's criticism report on that leg also fails. So 2 out of 3 knocked out. We don't need to go to the third one, like Justice Matopo, etc., on the question of the distinction between prima facie evidence and sufficient prima facie case. Not prima facie evidence, it's prima facie case, and sufficiency of evidence. The Mokokwa case raised in the debate with Justice Majid is an interesting one. And it's for this reason. In South African law, under Section 10 of the Extradition Act, 10.1 and 10.2, go and look at that. The question arises as to whether in the foreign state who sends an extradition request to South Africa, Mr. Rob, there is sufficient evidence to warrant the prosecution in that state. And what happened in Makwakwa, so sufficiency of evidence to warrant a prosecution, that's the term of art in South African law. And I'll come to a broader argument about that term of art, sufficiency of evidence. It's a 1962 piece of legislation which was amended, I think it's the early 2000s, to include that section, sufficiency of evidence. I think in 1962 it was prima facie, but I'll come to what. And what happens is section 10.2 says, when the foreign state requests extradition for determining the sufficiency of whether the foreign state has sufficient evidence to prosecute, a certificate from the foreign prosecutor suffices. What happened in that case? The foreign prosecutor in Lesotho says, we don't know, he didn't say that is what actually happened. He issued a certificate. And the certificate said, we, the prosecutor, have prima facie evidence to prosecute the man. And the defense in South Africa said, the certificate said there were prima facie evidence, but these got to show it's got to be sufficient evidence, a la section 10.1, and read with section 10.2. Therefore, I win my extradition, because the certificate is bad. The High Court said no. And if one reads paragraph 40 of the High Court judgment, the point is very neatly made as to why the notion that this court has been debating about this big difference between prima facie case and sufficiency of evidence is really a red herring. And it needs to be the first to say, I know the debate, I think it was with Justice Majid and Mr. Primy, touched my heart on the question of, in the criminal matter, if the trial judge gets it wrong, of course the conviction must fall. And in the case of ATM in the Supreme Court of Appeal, when Mr. Primy acted for the Speaker, I acted for the ATM, and I lost in the High Court, and I came to the SCM, I said, hey, the Speaker got the test wrong. The UDM case had given a blank slate, and the Speaker said there's a default position. You can't have a default position if you use a blank slate. And the SCM held my argument. The point I make is, I accept, as I must, that if the decision maker gets the wrong test, like the criminal court gets the wrong test, as a matter of principle, the conviction will be set aside. As a matter of principle. But what's the principle here? There's none. And let's read Makwakwa. Paragraph 40. There are varying degrees of prima facie evidence. Prima facie evidence can consist of incomplete evidence, for example. A single piece of, because remember, this is an answer to the question of the certificate from Lesotho saying they've got prima facie evidence which doesn't satisfy the South African Section 10 test of sufficiency of evidence. And this is what the High Court says, and we submit correctly so. So, what does it say? Prima facie evidence can consist of incomplete evidence. For example, a single piece of circumstantial evidence, a fingerprint, which will easily dissipate in the face of a plausible explanation. On the other hand, it may be a strong prima facie case, e.g. eyewitnesses, forensic evidence, and a confession. Prima facie evidence at its weakest is sufficient evidence to institute a prosecution. Highlighted. Prima facie evidence to warrant a prosecution in all manifestations, weak or strong, will therefore constitute sufficient evidence to warrant a prosecution. End of the story. There's no debate. I want to add to that. All over the world, in these kinds of cases, you have different tests. In the United States, it might be probable cause in some states. In Europe, there's different standards in the criminal prosecution, when you start and when you don't start. And I take Justice Colopin's point, that there's a difference in use of language, and there's the answer, Makwakwa. It's a different type of debate when the speaker tick box and when the panel tick box. So we submit, we only have to come home on one of the four. The further evidence that they're waiting for, not a good reason to strike down the report. Of the other three, all three are bad. The President and the ANC's reasons, all three are bad, but we only have to come home on one of them, on Westinghouse. So we come home. I turn to the rule, because I made the point that the rule is bad vis-a-vis EFF 2. I have to accept there's a delay problem and a potential mootness problem. I agree with Mr. Primy fully that the court says we would submit is obliged to consider at least the rule. The rule can never become moot. The rule's on the books today. It's a new parliament, it's got the same rule. So mootness is already as far as the rule is concerned. In principle, I suppose, in principle, but I don't concede it, in principle an argument could be made that the striking down of the resolution could be moot. But we don't concede it, but that's just an in principle argument. As far as delay is concerned, any one of the 400 members of parliament today could bring a challenge to the rule. And nobody can accuse that member of parliament of saying there's a delay. It's a rule, it's alive, it's operative. And either it's bad or it's good. It can never be suggested that this court could abdicate its responsibility to avoid looking at that rule now. It's on the books. So why do I say that the rule is bad? Well, we've had debates about what the Assembly can or can't do in order to achieve the result of an ultimate Section 89 impeachment. And I want to turn, well, before I do that, let me turn to EFF 1. EFF 1, Justice Matopo had a long debate with my learned friend on the question of the people telling the representatives what to vote or not vote, or the representative issue, separation of powers. Justice Sigerman raised it, many of the judges have raised it. The court would be minded to consider paragraph 10 of the order in EFF 1, the Nkandla judgment. And this is what this court ruled. Chief Justice Mokgeni, the resolution passed by the National Assembly, so it's a resolution passed by the National Assembly, that's what we're busy with here, absolving the president, it's a different president, it's the same thing, absolving the president from compliance with remedial action taken by the public sector, and you could take those words and put them in here, from enjoying the benefits or the disadvantages of an impeachment committee in terms of whatever section it is inconsistent with Section 42.3, 52.2a and b of the Constitution, invalid and set aside. So this court is well geared to taking on the separation of powers red herring. It's done so, it did so, as long ago as Mohammed, tak, grootboom. Separation of powers means this court's got to do what this court's got to do, and if there's an unlawfulness or an unconstitutional behavior by anybody, including the National Assembly, including the President, this court has a constitutional obligation to say so. So separation of powers doesn't come into the picture if the National Assembly acted unlawfully. I've already showed you that it acted unlawfully because it acted for two big reasons. One of which had three tributaries, all four are bad. On the ANC and the President's version. So we come to why I say this rule, 129I, or 129I in the context of 129 as a whole is bad. When one looks at the majority of EFF2, one has to compare it with what the minority said, because it doesn't have to just see what the majority said. As we understand it, there was a complaint about the president, former president. And there were no rules set out as to how to get to a final vote on impeachment. And what the majority said, there need to be rule-specific, a rule, dealing with impeachment like Mazibuku versus Sisulu in the motion no conference context. And there wasn't such a rule, therefore you, National Assembly, go make a rule in order to comply with the Constitution, and they made a rule. But in making that rule, they had to look at what was the rule about. So I'll start off at 192. Because what 192 of EFF2 does is it tells Parliament what it can't do. And what it can't do is have a political majority stymie an impeachment committee hearing if there is prima facie evidence, sufficiency of evidence. That's what it tells Parliament to do, and that's exactly what Parliament has done in this case. It is allowed for the 129 process to be politicized by that vote after the panel reports. That's what JAFTA JA warned against and said, you can't do that, and that's what they've done. So in 192, the rules relevant to the establishment of the committee, those are the ad hoc committees that Parliament can establish, which the minority found were okay. And now he says why they're not okay. Do not determine the size of a committee, nor do they require that all parties be represented. They merely state that the resolution establishing such committee must specify the number of members to be appointed or their names, if more than one party is represented, etc. The majority party would have majority representation. Now we start. This raises the risk of an impeachment complaint not reaching the Assembly, even if the resolution established in the committee were to stipulate that what was before the committee may not be decided by consensus. There, underline the following sentence. A decision by members of the majority party in the ad hoc committee may prevent an impeachment process proceeding beyond the committee to shield the president who is their party leader. That's what happened here. In recognition of the point that impeachment proceedings are partisan, the acting speaker said, the initiation of such proceedings is inherently partisan. Acting speaker in that case said that. As the aim from the outset is the removal of the president, who will almost always be the leader of the party represented. And then 193 segue into the point that I'm going to finalize my presentation on. In the context of section 102 of the Constitution, this court in Mazibuko, I've indicated the reference, the proposition that the tabling of motions of no confidence envisaged in that section with only the support of a majority was consistent. This court said that was rejected. That proposition was rejected. And I'm asking this court to reject what happened here in the same way. What 129I does exactly what was rejected in Mazibuko and in EFF 2. It's a repeat. Repeat. That's what this is. A majority decision, this court said in Mazibuko, a majority decision of the program committee on the scheduling of a motion no confidence could frustrate the vindication of the right envisaged in 102. This would be so because, again, as in the case of consensus requirements, it would be within the discretion and generosity of the majority within the program committee where the motion no confidence the president would ever see the light of day. And now an important sentence, which the rule gives absolute violence to. By parity of reasoning, the committee system is not suitable here too. So what the court says is this, what this court says is we have a committee system where the majority determine whether the thing should go forward. Not a good idea, it's unconstitutional because the majority will stop the inquiry but you won't see the light of day. We have it worse here because here's a panel report sent to the National Assembly, which could be another term for an ad hoc committee, because an ad hoc committee is just the embodiment of the National Assembly as a whole. So what one has is Parliament may strike down the report. Broad, wide discretion makes no difference. This rule is bad because it falls foul of what this court determined needs to be done when it comes to a Section 89 rule. I've used 7 minutes 30 seconds, and I'm happy to waive the extra 2.5 minutes, as it pleases you, Chief Justice.
Thank you, Mr. Coates.
Mr. Katz, just briefly, you referred to the committee system as being bad, imposing, as it were, the tyranny of the majority over the minority.
So, excuse me, sir, I'm
imposing the tyranny of the majority over the minority. Now, it's been said that, democracy is probably the worst form of government, but until we find a better system, it's the best we have. Under those circumstances, are you suggesting that the manner in which the National Assembly conducts its business and votes, and it engages the Constitution, but it's also an intensely political process, that this court should, in your invitation to set aside the rules, reach the conclusion that because rules, which on the face of them may be intended for people acting in good faith, could however be abused, and purely on that basis reach the conclusion that the rule is inconsistent with the Constitution? Would that not be, one, placing the court in a position that I don't imagine the drafters of the Constitution could have ever contemplated, is exercising this sort of superpower that even the Constitution doesn't contemplate. And doesn't that undermine, as it were, the workings of the National Assembly? Because in truth and reality, the National Assembly will take decisions that people may be unhappy with, and there might be an abuse of the system in place. But to fine-tune that, to take away, as it were, the exercise of the democratic will under circumstances where it may not be constitutional, could have a chilling effect.
Just not in this case, but I missed the sentence, because you also you put a particular sentence to me, which was a very important one. Could you just repeat it? I just wanted to be clear.
I put many important, all my sentences were important, Mr. Katz. But what do you recall of it that was so important? Then I can try and only know it.
Let me try and answer all the important questions in one answer.
Okay, thank you.
I have to accept, not have to, I don't have to accept it, we accept that as a matter of principle, ultimately, it's for the National Assembly to determine whether there should be impeachment or not. Ultimately. And when it does so, it must do so rationally, lawfully. But ultimately it's their decision. If they are paid, if every one of those members are paid to vote in a particular way, yes or no, that's not a rational, not a lawful decision. And I don't believe that this court could have any qualm with that. So the real question is this: did the National Assembly, and I want to come to, we're not even at impeachment. We're not even at the impeachment committee yet. We're at a far stage. We're not even getting to what the EFF2 said was frustrate and even debate about the issue. We haven't had a debate about impeachment yet. That's the 89 committee. So now what the majority have said is, we're stopping even a debate on impeachment, even though there are prima facie sufficient evidence, bad faith, all of those things in this case. That effectively. Now, can it be rational for them to do so? And we said, but obviously not. How can they strike down a report, if I use that language, when the basis for them doing so, and you've read what the ANC said, you've read what the President said, is flawed. So they go to the National Assembly and they say, don't vote for this report because it's bad. And then it turns out the ANC was completely wrong. The President was completely wrong. How can this court allow that decision to stand? That would be, in our view, anti-constitutional. It would be an outrageous violation of the Constitution for Parliament to pass a resolution on any matter in circumstances when they were misinformed. They were told the wrong facts, they were told the wrong law, and they voted. I'm not worried about the party system, we understand that. The EFF do it. My client's only got 2 members of Parliament, so hard for the leaders to...
your client is an important party.
It's important that this court recognizes that when Parliament acts, it acts rationally. And whenever it does so for good reason, not for bad reason. And when it acts for bad reason, and an important matter like this comes around every 10 years, impeachment of the President. And if we stand back, I mean, the elephant in the room, what's the elephant in the room? A couch with $500,000 they're unaccounted for. They will all just turn a face to that. That's what the elephant in the room is. And the President hasn't had his day in court. He hasn't had his inquiry. No tax. Reserve Bank say they've got no record of these money. If it happened to any of us, we wouldn't be sitting with a clean bill of health as it was today. At least we'd have had our day in court, and we might have won. We might have said, oh, it was advice, it was this, it was that. There's the elephant, standing there.
Thank you, Mr. Katz. You've gone considerably way beyond answering that question. But just finally, if you say ultimately all that we may need to deal with is the rule, and if there's no application for direct access, then if that's all that we left with residually, why should this court then deal with that just now, and why would that not be appropriately dealt with by the High Court?
No, I don't say that all you left was the rule. I say that the rule and the resolution.
You said that even if we don't, we are not with you on the resolution, we should at least then deal with the rule.
No, I think the other way around. I think what I said was this: if you're with us on the rule, then you bring both legs, the rule and the resolution. But if you're against us on the rule, then you've got to go to the resolution anyway.
Okay. I'm sorry, Mr. Katz, maybe I sort of misunderstood the importance.
I apologize if I didn't make it clear.
Mr. Katz? Mr. Katz?
Oh, sorry, Justice Mshlamfa.
Thank you.
No, I saw something.
Okay. I still want to go back to the delay point that you've touched on. And my concern is that the cases that you have referred us to, there the explanation for the delay was provided. And what we have, there is no explanation whatsoever.
Yes.
And normally we get an explanation, we then have to decide whether the delay is undue, whether we should overlook it based on the explanation. What should we do when there is no explanation whatsoever?
I've got two answers.
Okay.
The first is delay is a red herring in this case. It doesn't play a role at all, because you can always challenge the rule. You can challenge it today, and nobody can accuse me of delay. It's there, it's on the books. For the purpose of the rule. For the resolution, I accept the proposition. The second answer that I give, this is such a serious matter. And yes, I can talk about the elephant in the room, and we all know what's going on here. What do the interests of justice say? In this case, excuse the delay, deal with the resolution, and if you find that the resolution was okay, it was rationally passed, then my client has to live with it. He laid the complaint with the Speaker. The Speaker gave him a tick box. Panel gave him a tick box. He hasn't had an impeachment committee hearing. That's serious. It's a very serious constitutional matter. And for this court not to consider the substance of the challenge to the resolution because of delay, we would submit, would not be in the interest of the Constitution. It's as simple as that.
Now, coming back to the rule itself,
Yes.
assuming that the issue of direct access is not a problem, and then one is able to deal with the challenge. And if we are with you and the EFF on the challenge, the outcome that is sought is that once a report is submitted by the panel, it should not go to the National Assembly. There should be no vote on whatever.
I do apologize. It was in my 10 minutes. We submit the following, and I haven't typed this up, and it's not going to be fair on my respondent colleagues, but this is the submission. I had said in my address that 6.1 needs to be tweaked, and this court will decide how to tweak it. Because clearly the rule is, in our view, the rule is clearly unconstitutional. The problem is, and it's a difficult problem, and I haven't got the full answer, how do you tweak 6.1 as the EFF have drafted? How would the ATM suggest that 6.1 should look? And I've got it written down, and it's a simple variation of 6.1. The rule, let's call it rule 129I, but it's really 129I in context, is unconstitutional to the extent, because that's what 172(1)A tells the court. You declare something, a piece of statute or a regulation or a rule, unconstitutional to the extent that, and then you decide what the extent is. It treats, sorry, it treats a determination of whether the President committed a serious violation of the law as a political issue question, and it shouldn't. It's a legal issue, it's a black or white issue. The panel plays no political role, none. And so the real issue is the question that the panel had to look at, the sufficiency of evidence and the Section 89 criteria, should be regarded as purely apolitical. It's nothing to do with who the president is, which party he belongs to, did he elephant in the room the dollars.
So one should look at the substance of the report, and not one should look at the substance of the report, and not a party line or how one should vote.
No, I'm not trying to. Sorry, I must.
No, I'm saying you are saying the issue of party line, how one should vote, should be excluded when it comes to.
Absolutely. When it comes to the question of accepting the validity of the report and to whether to have an impeachment inquiry, there should be no party interference in that decision. It should be, not what I say, it's what this court said in EFF 2. EFF 2 said that. It said, when it comes to whether or not there should be an impeachment inquiry, politics can play no role. I've just read it to you by parity of reasoning. That's what I've read to you. And that's why, when it goes to the National Assembly, and we know, the answer is here, the ANC tell us. The ANC tell us it went along party lines. The ANC looked at the report, didn't like the report, told their members what to do. We haven't got a problem with that, as a matter of principle, for this case.
My understanding of the EFF's case is that, in fact, the referral to the Assembly should be excluded altogether. So from the panel straight to the impeachment committee. That's what they are seeking.
If that's the effect of what I'm saying as well, but that's not for the court to decide. All that the court has to decide what they've actually done. The rule that they've actually made is bad. You don't have to decide how they should fix it, whether it should go straight or whether the National Assembly. That's not for this court to decide. That would be a separation of powers potential problem. All that this court has to do is say it's bad. It doesn't have to say, well, it's bad, this is how you fix it. It's not for this court.
Thank you.
Mr. Katz, you said that the National Assembly decision would fall automatically if your attack on the rule is good. Did I understand you correctly?
This is how I understood my submission. We submit that the National Assembly resolution was bad.
I've heard your argument as to why it's bad on its own, leaving aside whether the rule is good or bad. But I understood you to say in the first instance that if the rule is bad, it automatically vitiates the National Assembly's decision.
The answer, yes. I accept, sorry, Justice Rogers.
Well, my question was going to be that would be true only if the rule were retrospectively invalidated.
And that goes to section 172(1)(b) type consideration. I accept that.
And the applicant, at least, I'm not sure if in your client's papers it argued for it differently, but the EFF asked that the declaration be suspended for 12 months. So that's paragraph 7 of its notice of motion.
Yes, Justice Rogers, the answer to that is suspension doesn't mean no retrospectivity.
Yes, but it means that the declaration is not operative at all.
But it becomes operative at the end of the suspension.
Yes, well,
and that's why
that means we can't now take any decision about the National Assembly rule on the strength of that declaration, which has no current effect.
I would submit that they're separate prayers. So the suspension prayer and the striking down the resolution prayer are different in kind.
No, they are. I mean, they're different numbers. I don't care whether they're A's or B's or 1s or 7s. I'm only concerned just to establish that unless we refrain from suspending the declaration and make it retrospective, which would be the usual position unless we limit retrospectivity, then there is no domino effect on the National Assembly's decision.
So perhaps, yes, Justice Rogers, I have to think about it. I'll come back and reply. But I'm interested, was my submission that prayer 7 should be granted or not? I just want to remind myself.
My own notes had a question mark against prayer 7.
Yes.
Perhaps you should now say it should be struck.
There should be no prayer 7. That's the answer. Yes, and the reason is they haven't made out a case for that suspension. My learned colleagues on the right to speak in the present.
Make out a case if the applicant asks for it.
I accept that, but that doesn't mean to say that the applicant has made out a case for it. Justice Rogers, the simple proposition is this. There's no reason on the papers why there should be a suspension. In EFF 2, there couldn't be a suspension because there was no rule to suspend. But the proposition... Yes.
I suppose, the question, I suppose, is always, if there's no suspension, what chaos would ensue were the declaration to come into operation immediately? And we can't think of any. But it's none of the papers. I mean, I know that a couple of weeks ago, I think Justice Rogers, you weren't in the case, but Justice Malema asked me the question that where there's no evidence in a Section 36 limitations inquiry, should the court nevertheless inquire into when it's a rationality challenge? And I answered, I think tentatively yes, and I'll wait for the judgment, but the problem, I don't know what's going to come. But the problem, the issue I suppose, is that answer in that case would probably be a similar answer here. This court can look and see would there be chaos were the rule not to be suspended. But I can't think of any. I can't see any new presidents facing an impeachment with a rule that with 129I is bad. Can't see it.
Then my other question has to do with what you read out as to the extent of the invalidity of the rule, the basis of the invalidity that you suggest we might grant. I understood the essence of it to be that it would state that it is invalid to the extent that it treats the determination of the question whether the President has committed impeachable conduct as a political question.
For purposes of determining whether there should be an impeachment committee,
Yes.
that's the essence, yes.
Now, from that, do I understand your submission to be that Rule 29I, as it currently reads, treats that as a political question? In other words, on a proper interpretation of Rule 29I, does it treat that question as a political one, or does it treat it as a question on which members of Parliament must vote according to what they think is right?
Well, we will submit those, the two propositions that you put, the two distinctions are one and the same.
Yes, that's why I put them as I did.
But
If treating it as a political question is the antithesis of considering what you believe to be right, I would have thought.
it shouldn't go to Parliament because going to Parliament, it's treated as a political question. Parliament is in the business of politics.
But it has to go to Parliament.
Yeah, well, as the rule stands.
Are you saying that Parliament should not actually be involved at all?
No, what I'm saying, that's what I think I answered Justice Mashrantla by saying that. I'm not giving an answer to the question. I'm just posing what the problem is. When the question goes to Parliament as to whether there should be an impeachment committee at all, it's a political question as to whether there should be an impeachment committee, and EFF2 said that's a bad idea.
Yes, but do you say that by declaring the rule invalid to the extent that it treats it as a political question, do you equate that with saying that Parliament, the mere fact that Parliament can consider that question makes it a political matter?
As it pleases the court.
So what you are saying is that at the stage of the IP report and whether the next step of a referral to the impeachment committee should happen, Parliament must simply not be involved, because as soon as Parliament is involved, it is inherently a political matter.
That's what EFF2 says. And we support that.
Well, certain other propositions were put to Mr. Primy by my colleagues to the effect that EFF2 seemed to indicate that Parliament did control the process, and including this question. I might be wrong, but as long as I understand you, you say the first time Parliament must consider the matter is when the impeachment committee has done its work.
Effectively.
Because up to then there'll be a party's motion, a speaker checking that it's in order, an independent panel which does not consist of parliamentarians, then an impeachment committee I assume it consists of, does it consist of parliamentarians?
Only parliamentarians.
Yes, but a small body of parliamentarians, and finally it comes before Parliament to decide, do we impeach or not? Do you say then it is a political question?
Yes. Yes.
So at that stage,
yes,
it can be decided politically regardless of the merits.
And I'm thinking of a classic example. I was trying to think of examples where at the end Parliament could act rationally but reject the impeachment committee's finding that the President had acted in violation of Section 89. rationally, like emphasized. And one can think of a case where, for example, the president's got a few months to go of his presidency. He's committed a serious violation under 89(1), whatever the section are, in bad faith. And to impeach him at that point may not be in the interest of the stability and otherwise of the country. And there could be a whole range of, let's call it, extra 89 reasons. That's the best I can give. Because otherwise we're in dangerous territory of saying that National Assembly at the end also must be bound by the Impeachment Committee, and I'm not going to make that submission. Ultimately it's for Parliament to decide.
Then, if I may say, you may wish to go back and reconsider your formulation of what you're going to ask us to do, because it seems to me not to say directly what you actually intend.
Yes. No,
what you actually intend is that the whole of Rule 129I is invalid, because that rule is only concerned with the matter going to the National Assembly. And if that inherently makes every feature of that you say the rule as a whole is bad.
As it pleases the court, yes. I did say that I had struggled tweaking it because the way it's formulated currently in 6.1 doesn't give effect to what we really submit should be the answer. I know Mr. Primy has argued for it in the way that I've argued for it.
Yes. You see, my concern was that the way you formulated it would suggest that it could still go to the National Assembly, but the National Assembly and its individual members must not treat it as a political matter.
Yeah, I accept.
Whereas you say it just shouldn't go there at all.
Absolutely. I thank you, Justice Rogers. You've clarified the submission that I wish to have made. Thank you, Chief Justice.
Mr. Kurtz, I have two issues, but I'd like to start with this one now because it's fresh in your mind. You're an intervening party before the court. Just as a matter of procedure, you seem to want to suggest that we should get rid of paragraph 7 of the notice of motion. Shouldn't you first get a mandate for that, in as much as you're acting for a two-person party then, not the applicant? I say it tongue-in-cheek only half, because I think it's a serious question.
It's a serious question.
Intervening party, you can do that.
Well, I'm not sure that we are an intervening party. That's my first answer. We're an applicant. We were a respondent.
Oh yeah, you're an applicant.
What happened here was we were a respondent, and if there's an interesting law, which I've learned, in ATM versus the Speaker of the full bench of the High Court, which is about this very resolution, but whether it should be secret ballot or not. And what happened was the ATM were the applicant, and the respondent included the EFF. And the EFF supported us. And the ANC said, no, they must come in as an applicant if they want to do so, because it's not fair to the respondents. And that's what we recognized in this case. So the ATM joined the EFF.
You also said so in the elections case, that the judgment that I wrote, remember? Oh, you wouldn't remember. But
Which
anyway.
one was that?
But this is the point. You came in as an applicant, but whose notice of motion is this? Is it your notice of motion, or is it the EFF's, or both of you?
Both.
And if it's both of you, is 50% enough to get rid of the paragraph 7? I'm asking you because I think you might take instructions or enter into negotiations with the EFF.
Let me say this. It's actually me talking. I've also got a responsibility to the court as an advocate. So even if there's what the client might want, I try never to just do the client's bidding. I try to at least make submissions that I believe in. Sometimes I succeed and sometimes one doesn't. But the proposition is, I'm not sure that paragraph 7 of the notice of motion is necessary from a legal perspective, but I'll leave that to the court.
That's the best traditions of the bar, and that's a duty of counsel to the court. You're right.
Thank you.
But here's my problem. If paragraph, I think you have disavowed paragraph 6.1. You see the difficulties there with 6.1.
In its current formulation.
In its current formulation.
I do submit that, as the debate that I had with Justice Rogers, and this court knows from all its cases, Modderfontein, I think it's the EFF, Public Protector Gordon case, this court can fashion the remedy even if it's not that which is included technically in the notice of motion. And I've struggled, I'm not saying it's been difficult for me to come up with what would be the perfect formulation of 6.1. But it certainly needs to deal with 129I in a way that I had read, that there should be no political interference before the impeachment committee starts. Whatever you do with 129I, if it achieves that, we are happy.
And my question really is about 6.2. Because if 6.2, if we grant 6.2, what we are saying is this. We say that you have a panel that comes to a decision, and you now bypass the elected members that the electorate put there, and that panel will say there must now be an impeachment committee. In other words, the National Assembly has no say over it. I'm just talking about 6.2.
I haven't asked for 6.2. And that was my answer to Justice Mashlantla. I'm not asking this court to tell Parliament what it must do. What I'm asking this court to do is to tell Parliament that which it's done is unlawful. That's why I stop at 6.1. 6.2 goes that step further.
So one last question from me. I don't know if you have EFF2 open in front of you.
I do.
But you read 193, 194, and 195. I just want to ask you about a remark that Justice Jafta for the majority makes in 195.
Yes.
He says here the applicants did not seek that the rules be declared invalid, that's in EFF2, to the extent that they failed to provide for regulation of impeachment proceedings. But the similarities between Mazibuko and this matter are remarkable. That said, however, and this is the part that I'd like you to consider and tell me if it makes any change to what you've submitted. That said, however, section 102.2 with which the court was concerned in Mazibuko does not require proof of any conditions before a motion of no confidence is tabled, debated and voted on. Here, grounds for impeachment must be established before the motion to remove the president from office is debated and voted on. Does it change any of your submissions, this caveat that is added?
So in Mazibuko, well, I don't have to repeat it, but in Mazibuko, the parliamentarians can say, we don't like this president anymore. Gone. Here, they can't do that for a whole range of reasons. He has to be found, if I may put it that way, jurisdictional fact that he's committed one of the section 89(1) transgressions. That's the difference between Mazibuko and, sorry, the difference between 102.2 and 89. I'm not sure that.
Well, let me put it directly to you. What EFF2 says is that unlike Mazibuko, there must be jurisdictional grounds before you can get to the impeachment.
Yes.
And that is why those jurisdictional grounds must be properly before.
Yes, I see. Yes. That's yes, of course. That's 129. 129 JKMN all the way through to O. There we have it. We don't have that in Mazibuko. We don't need it in Mazibuko, but we have it for you. That's why there's only a challenge to I. So that's the sifting of the jurisdictional facts.
Thank you, CJ.
Thank you, Mr. Kurtz. We should take the lunch adjournment for 30 minutes. Would you be comfortable with that? Okay. We'll come back at 1:30.
I think he's running up better.
Fighter fikile kweli shumi, fighter titifuma kamnande. Ama fighter fikile kweli shumi, fighter titifuma kamnande. Ama fighter fikile kweli shumi, fighter titifuma kamnande. Ama fighter fikile kweli shumi, fighter titifuma kamnande. Julius Malema phethu mshini vuma kamnandi. Julius Malema phethu thando vuma kamnandi. Julius Malema phethu kodwa vuma kamnandi. Julius Malema phethu mshini vuma kamnandi.
information, namasa, chula information, lage, kichi kichi, kichima, Zipram Konto, Alliance, Onke Laban, Ebaget, Celta Tile, Elaget, shoot to kill, namasa, shoot to kill, kill away, shoot to kill, namasa. Hey, ta, hey, ta, Zipram Konto, Alliance, Celta Tile, Laget, Celta Tile, Laget, hey, ta, yeah.
Oh, Magam
kunomntwana la umama akhe akazi ukuthi umphi kunomntwana la ulahlekile sicela umama lo mntwana ezimva ke stage
Tembisile Hani Sapriti. Fighter Tietzi Mutibe from Ebuleni, North Sapriti. Fighter Kenny Montane from Ebuleni, North Sapriti. Fighter Teko de Hale from Ebuleni, North Sapriti. May their souls rest in peace. The struggle continues. Haluta continues. Hey!
Malema, straight to Malema, straight to Mugabe, Sayana, Malema, straight to Malema, straight to Mugabe, Sayana.
lendawo hawo yona lendawo esekuyo hawo tina sayisawo hawo yona lendawo esekuyo ebathule nje baziqiniso awuyo yo yo esekuyo ebathule nje baziqiniso awuyo yo yo esekuyo awusikhokele Malema awuyo yo yo esekuyo awusikhokele Malema awuyo yo yo esekuyo ebathule nje baziqiniso awuyo yo yo esekuyo ebathule nje baziqiniso awuyo yo yo esekuyo ebotina sayisaba lendawo hawo yona lendawo esekuyo ebotina sayisaba lendawo awuyo yo yo esekuyo ebaphethe sibamezibotshomlelo awuyo yo yo esekuyo ebaphethe sibamezibotshomlelo awuyo yo yo esekuyo awusikhokele Malema awuyo yo yo esekuyo awusikhokele Komanda awukodwa lendawo esekuyo ebathule nje baziqiniso awuyo yo yo esekuyo abotina sayisaba lendawo awuyo yo yo esekuyo abotina sayisaba lendawo awuyo yo yo esekuyo ebaphethe sibamezibotshomlelo awuyo yo yo esekuyo
I-Afrika
hayibuye bathi Mzansi Afrika izwe lomama bathi izwe lobaba awe ayamaphono bathi Mzansi Afrika izwe lokhokho bathi izwe lomkhulu awe ayamaphono bathi ayamaphono ayalebala athingelabo kodwa ngeletho kithi Koni EFF awizobashaya Koni EFF atishaya Koni EFF awizobashaya Koni EFF
Argument that the rule goes too far, but that's not before the court. And the question arose as to whether in striking down the report, the panel properly took into account the question of bad faith. So it's not us saying that the President acted in bad faith. It's really a question of whether the panel properly interrogated bad faith. And what the panel did, if we understand it properly, is in the paragraphs that I read, I think it's particularly paragraph 63, the panel said, you can't look at bad faith on the basis of what the President says. So the President didn't. He filed a letter, and he said, I wasn't acting in bad faith when I did what I did. He said that. And the criticism by the ANC and the President is, well, the President said he acted in good faith by doing what he did, and therefore the panel was wrong to find that he acted in bad faith. And what the panel's, what the true import of the panel's report was this: you can't look at what the President says, you can't look at what General Rhoda says, you've got to look at all the facts and circumstances, and you draw an inference. And what they did was, they said if you look at all the facts and circumstances, by parity of reasoning, he acted in bad faith. No further than that. And the criticism that they didn't consider bad faith is a bad criticism, because they did consider bad faith. And so the way they dealt with it might not have been the way I would have dealt with it, or the court might have dealt with it, but they dealt with it. Whereas the ANC and the President said they didn't deal with it. That was the high watermark of my submission.
But that is the finding that they made about bad faith.
They were had to.
Yeah. So we have to ascertain the basis of that bad faith by the panel. What would be those facts, the elements of bad faith?
That what the President did once the theft was brought to his attention, you look at what did he do after the theft was brought to his attention, and what did he do before? What was he doing with the dollars in the couch in the first place? What's his explanation? And if one sees that globular picture, the panel says that globular picture points to bad faith. Globular picture, fact by fact by fact. Like in circumstantial evidence. Why is the man guilty? Drip by drip by drip until there's a river. That river is why the man's guilty, not the President. That's how circumstantial evidence becomes evidence to convict a murderer, for example. And what the panel did, drip by drip by drip. Why didn't he report it to the proper authority?
But he reported to Rode, his special advisor, or
Special protection unit.
Yes.
He's got nothing to do with Brecker or the prevention of corruption. He's a security policeman. And he goes to Namibia, Cape Town. And you look at those facts, drip by drip by drip. It's not one fact. You look at what did the president do, big picture. Why? And the question is, why were the dollars in the couch?
But he wouldn't know why the dollars were in the couch. It's an ex post facto application that was given why the dollars were in the couch. Whether it's right or wrong, whether it's preposterous, it's something else. He was just reporting why the dollars were in the couch. Everybody, you and me, would be astounded to say, why are you keeping the dollars in the couch? But they were there. They were stolen there as allegedly as we are told.
Well, if with respect, I agree with you, Justice Mantopa, that I would be astounded. I am astounded. I think all of us can be astounded that $500,000 are found in a couch. And there needs to be an explanation for why they were found in a couch, number one. He says, well, I didn't know about it, there were these advisors that put it there, or whatever the explanation might be. But then what does he do? He says to his security guy, go and report it. Well, no, he didn't say to the security guy, and he didn't do that. No, he didn't do that. He reported it to the security general. So that's not appropriate. That demonstrates bad faith. With the whole picture, that's the answer. I can't do better than that. But how could, the question I suppose is this. In a case like this, what would the ATM, what would Mr. Zungulu have to produce by way of evidence to show bad faith? What he produced. And then he says, and then the president goes to the Limpopo ANC, says, not a problem, I'm a farmer. That's why the dollars are on the couch. That's a violation.
No, that's not what he said. No, that's not what. That's not what he said.
Well, that's the debate. Yeah. What I'm trying to say is, what was he doing with the dollars in the couch other than business? And Justice Motropa, you put to me, well, there might be explanations for why the dollars were in the couch. There might be. But certainly not one that are consistent with...
There is an extensive explanation given by one of the workers why the money was in the safe, and suddenly the safe is not safe, and they put it in the couch. The president doesn't know about it. You and I can look at it and say, with suspicious mind, to say, it's supposed to be safe in the safe. Take the keys with you. But that's not what happened.
Justice Matropa, that's why you have an impeachment committee hearing. You and I think of it. That's what the public are there for. We want to know what happened. You have an impeachment committee hearing by the Committee of Parliament, and at the end of that committee, there might be, the president might come out white as the, well, no, that's, I don't want to be racist, but he would come out as clean as the driven snow. He'd come out clean. No. So, the point, that's the truth. He isn't clean at this stage. And the panel fine. He's not clean, the bad faith. It's not for, and you shouldn't second guess them. Panel. Why should Parliament second guess them? Drip by drip by drip. That's the best I can do. They can't point a particular thing that he did, which was bad faith. And the question, the real question, leave aside all of the corruption and money laundering, and I'll ask the question rhetorically. What's the president doing business? The Constitution says that when the person becomes a president or a member of cabinet, he must cease doing other business. But that official's got cash in his couch. That's clearly a violation of the constitutional requirement that he doesn't do business.
But is this now your case, or it's something else?
No, it's one of the 4 charges that my client put to the panel, or put to the speaker who put it to the panel. No, they're all there. That's bad faith. There's no explanation for it. So that's why I said my client put before the speaker 4 charges. I don't need to repeat
that.
No,
don't.
All of those might involve ultimately a finding of serious misconduct of the Constitution and the law. But at a prima facie sufficiency of evidence that it certainly meets the standard of bad faith. And the bad faith requirement might even be unconstitutional because that doesn't matter. I shouldn't go there. I don't want to go there. But that's the point. Bad faith was not ignored by the panel. It was dealt with in terms. And for Minister Lamora to say it wasn't dealt with, or the ANC to say it wasn't dealt with, is factually wrong. That's all. The panel might have got it wrong, but that's not the point. They dealt with it. That's the point. Thank you, Chief Justice.
Mr. Brainbach?
Thank you, Chief Justice, members of the court. In our oral address, we're going to deal with two main issues. The first is we will endeavour to explain why the challenge to Rule 129I is ill-founded. And secondly, we will explain why in our submission the challenge to the National Assembly's 13 December 2022 resolution, which was taken in terms of 129I3, has been brought fatally late. Dealing first with then the challenge to the rule. I have to say I was somewhat taken aback by the submissions made by my learned friend Mr. Katz for the ATM on that topic today for the following reason. The ATM applied to intervene as an applicant in the matter. The application was granted by this court on the 29th of August, and this court added that it was granted leave to file written submissions and to make oral submissions. It did file written submissions, and I've checked them again. There is no attack on the rule in those written submissions. The focus is on the resolution of 13 December 2022. My learned friend went further. He argued that some of the relief sought in the notice of motion, specifically paragraph 6.1, should be amended, and that in the absence of an application for amendment. And we heard all of this for the first time today. I act for, together with my team, for the Speaker and for the National Assembly, whose rules are impugned in this matter. And with respect, we contend it is unfair that none of this was raised in the proper way in the written submissions in accordance with the directions of this of the Chief Justice in this matter. And we will accordingly focus on the cases pleaded in the EFF's papers to which the ATM joined. Now, they challenge Rule 129I on two grounds, as the court will know. They're advanced as alternatives, and each is coupled with a specific remedy. The first challenge, as we understand it, is that Rule 129I is inconsistent with two main provisions in the Constitution. The first is Section 55(2)(a), and the second, Section 89(1) itself. And more specifically, as those sections were interpreted by the majority of this court in EFF 2. And the reason, as we understand the challenge, is that it's unconstitutional. This is the first challenge, is because it allows the National Assembly to vote against referring an impeachment motion to the Impeachment Committee in circumstances where the independent panel has found that a prima facie case of impeachable conduct has been made out. And we see that summarized in paragraph 6.1 of the notice of motion. And if that first challenge is upheld, then the EFF, but on what my learned friend Mr. Katz said today, not the ATM, seeks an order directing, and this is paragraph 6.2, that the Speaker of the NA, the National Assembly, amend the rule in such a way that if the panel makes a prima facie finding, the presidential impeachment motion is automatically referred to the Impeachment Committee. May I just say that, of course, it's not open to the Speaker to amend the rules of the National Assembly. It is a matter for the National Assembly itself, but that is a relatively minor blemish in the case that we are facing today in the greater scheme of things. But as was put to my learned friends this morning, what has essentially been asked is that this court direct the Assembly to take the Assembly itself out of the equation until finally the Impeachment Committee is reported at the end of an impeachment trial before that committee. That is the remedy that's been sought. But it is, of course, dependent on the underlying proposition that it is unconstitutional for the rules to permit the Assembly to vote against the President's removal, the referral to the Impeachment Committee in circumstances where the panel has found that a prima facie case of impeachable conduct exists. So the two are inextricably linked, the reason for it and the remedy that are being sought. The second, which is the alternative challenge, second order challenge, is premised on the Assembly having a discretion. The first one, of course, is that there should be no discretion. They must simply be taken out entirely, and there must be this automatic referral. The second attacks the discretion. As we understand it, it is that the rule against vagueness, which is of course immanent in the constitutional principle of legality, is infringed because Rule 129I is impermissibly vague, and so the argument goes, it is open to abuse by the National Assembly. And the remedy which has been sought, if that second ground of challenge is upheld, again by the EFF, but not on my learned friend Mr. Katz's showing, the ADM, an order directing the Speaker, again, to amend the rule to include suitable guidelines structuring